Are we live? Good evening, everyone. Greetings from Rotaract Club of Yelahanka. I'm Rotaractor Varun Adhyapak, President of Rotaract Club of Yelahanka. Wishing you all a very happy Republic Day. It's always a sense of pride and happiness to have this national celebrations around. In the new normal, it's really mesmerizing to see all the kids practice their plays and skits and sit in front of the system and celebrate today. It's very glorifying to see the patriotism that is spread all across our social media handles. It's also a very proud moment for all of us to wake up early in the morning to watch the parade and the different tableaus on the Rajpath. Let us not forget the fact that today is the day when the Indian Constitution was adopted in 1950. We from Rotaract Club of Yelahanka are organizing Samvidan Bodh, where all our doubts on different phases, abbreviations, and also to educate all of you on different duties and rights that we all have to know as citizens of our country. So wishing you all once again happy 73rd Republic Day, and no further delay, I'll hand over to Gayatri to introduce the guest of speaker today.
Good evening, everyone. Today we have with us Professor Shivani Rajesh from Symbiosis Law School. Ma'am completed her BSL LLB from ILS Law College in Pune and completed her Master's LLM from NUJS Kolkata. Ma'am is currently pursuing PhD in International Trade Law from NUJS Kolkata. Ma'am takes immense interest in publishing several research papers relating to constitutional law as well as international trade law. It is indeed a privilege to have you, ma'am. Thank you so much for joining us with us today. Over to you, ma'am.
Thank you, Gayatri. I would first like to wish everyone a very happy Republic Day. It's the 73rd Republic Day that we are celebrating today. I would also like to thank Varun and Saurabh and the entire team from Rotaract Club of Yelahanka for inviting me for this session. And lastly, I would like to thank Gayatri as well. She has been a very good student of mine when I was working as an assistant professor in CMR Law School. And it's always a pleasure to get invited to such events, especially by someone who knows how I speak. Right. So thank you so much. Talking about the importance of the topic that we are going to discuss today, we are essentially talking about the basics of the Indian Constitution with a special emphasis on the part 3 of the Constitution, which is essentially the fundamental rights, right? Now, before we move on to talk about the fundamental rights specifically, I would like to highlight a few very peculiar features of our Constitution, right? And the reason for talking about the Constitution today is simply because today was the day in 1950 that we adopted our Constitution in the sense that it was enforced in our country, right? So this is also the birthday of our Constitution, if I may say so. And our Constitution is a very peculiar piece of, literature, if I might say, right? First of all, our Constitution is not a unique or a novel piece in itself. Large parts of our Constitution have been adopted or borrowed from other constitutions which exist in other countries, right? So if we look at various things such as fundamental rights, we have borrowed heavily from the United States of America. If we look at the fundamental duties, we have borrowed heavily from the Federation of Russia, right? And many other parts of the Constitution, which cannot be called as completely unique for us, right? But the thing that works and the thing which is really appreciable is how these different parts, which have been borrowed from different parts of the world, have come together in order to look like it's tailor-made for our country, right? And that is something which is absolutely commendable about our Constitution. Now, the first thing that we need to understand is the fact that our Constitution is not necessarily a reflection of what India is, right? our constitution largely is a reflection of what we aim to be as a country, right? So even when we look at the preamble of our constitution, it essentially lays down certain fundamental principles which we aspire to achieve rather than something that we have already achieved, right? So that is the basis on which we should look at our constitution. However, the thing remains that the fundamental rights are something which we claim is the present scenario in India. So whatever fundamental rights are guaranteed to us, it's not an aspiration, it is something which is a guarantee, right? Which means it is in existence currently. However, whether it is truly the case is a little debatable and is questionable, right? Another thing that I would like to point out about our constitution is that it is the longest constitution in the whole world. Okay, and here I would like to draw a comparison between the Constitution of America and India. Majorly, I will take throughout the course of this lecture the Constitution of USA as a point of comparison, because first of all, it is the oldest constitution, and second of all, for whatever reasons, it is one of the most celebrated constitutions of our world, right? So if we do a comparison between the Indian and the American Constitution, we realize that the American Constitution has a total of 7 provisions. That's it, right? And if we look at the Indian constitutions, we have 395 articles. Okay, so it's not double, it's not triple, it's an exponentially large number as compared to the oldest constitution that we have and is still in existence, right? In addition to these 395 articles, we have the constitution which is appended with 12 schedules. And these schedules essentially deal with different things. For example, the first schedule lays down the names of all the state which form a part of our Indian of our country, right? There is another schedule which talks about the list of languages which are recognized by our constitution. And there is another schedule which recognizes the division of power between the center and the state by distributing the subjects, right? Which is called as the lists which we have. So these schedules are also a part of the constitution, and this makes the constitution a very lengthy work, right? In addition to this, something which is extremely important for us to understand, and we'll also understand during the course of this lecture, is that our constitution is not something which is static, right? There's a term which is used for it, that our constitution is a living constitution, right? And the meaning of this term living constitution is basically that we should interpret the provisions of the constitution based on the context in which we live today, right? So for example, if we look at the original meaning of the provisions of the constitution, it may not be the same meaning that we continue to interpret it as even today, right? So context becomes very important. To give you a very simple example, right to equality, which is a very inherent part of our constitution, back in 1947, when it talked about right to equality means freedom from discrimination on the basis of gender or on the basis of sex. In 1947, it meant between man and woman. But today, it means between man, woman, and the third gender, which is the transgender, right? So this is the meaning when I say that our constitution is a living piece. It is not something which depends upon its original meaning. The next very important part of our constitution is that it is not static. It is subject to amendment, right? And this is considered to be one of the major reasons why it is believed that our constitution has sustained the test of time, right? These two features for that matter. One is the fact that it is a living document, which means its interpretation depends upon the context. And second of all, it is amendable, right? And here also, I would like to draw a comparison between the American amendments which have taken place and the Indian amendments, wherein the American Constitution has been amended for a total of 27 times. And to give a little bit of perspective, it came into existence in the year 1778, right? And the Indian Constitution, which came into existence in the year 1950, has been amended 105 times till today, right? So once again, a little bit of perspective into what is exactly the document that we are dealing with, what is exactly the context in which we are looking at our constitution, right? Moving ahead with this background, I would like to talk about the main feature of today's lecture, which is the fundamental rights. Now, fundamental rights are provided for in part 3 of our constitution, right? And even though I may not completely agree with it, it is considered to be one of the most important parts of the constitution, right? According to me, the entire constitution is important. According to me, I don't think fundamental rights are deserve a special status, right? Because if you look at the entire provisions of the constitution which talk about the powers of the union and the state, or the legislature and the executive, it is as important as the fundamental rights, correct? But fundamental rights is considered to be one of the most important parts of the constitution, which is the general perspective. And there is a reason behind it. And the reason is fundamental rights are something which protects normal people on a daily basis, right? So this is the reason why it is considered to be the most relevant for all of us to understand what are our fundamental rights, correct? Now, once again, before I move on to talk about the fundamental rights, I would like to talk about the background a little bit, right? Now, if we look at the constitutions of the world, once again, I'm drawing a comparison between the Indian and the American constitution. And this is true in case of many other constitutions, okay? But for the purpose of our understanding, we are only going to look at the American and the Indian constitution. If we look at the Constitution of America, if we understand its background, in the sense what is the history of this piece of this piece of legislation, we realize that the American Constitution has come into existence in the backdrop of the American Revolution, right? So in 1778, there was a revolution which was going on in America, which was essentially in order to end the colonial powers, that the rule of the colonial powers, that is the Britishers, who had at that point of time control over the American subcontinent, right? Now, when you look at this background, and this rings a bell for us, right? Because if we look at 1947, when the work on the Indian Constitution began, we also have had a similar background, right? We were also under the rule of the British Crown, and we also had an independence that was given to us by the Britishers in the year 1947, correct? So when we look at this background, we realize that the whole idea behind the drafting of the Constitution can be summarized on the basis of two principles. One is that the person who is governing us should do so based on the consent of the governed. In other words, democracy, right? So we do not want the British Crown to come and rule us. We want a person to rule us whom we have chosen, right? Based on our consent, the consent of the governed. That was the first principle. And the second principle is every person should have some kind of an ammunition within their control, which they can use in order to protect themselves from the misuse of the power of the government, right? And this is where the fundamental rights comes into picture. And this is something which is a very common question that I asked in the class, that what do you think is a fundamental right? And everyone says that it is a right which is given to the citizens, and it is a right which we hold, and it is something that is very dear to us. But according to me, fundamental right is nothing but a limitation on the power of the government, right? It prevents the government from doing certain things which infringes our right. So it is true that it is our rights, it is dear to us, but I don't think the people are at the center. At the center is the government, whose powers are being limited due to the fundamental rights, correct? Now, why does the power of the government need to be limited is another discussion, right? It is based on the principle of power corrupts and absolute power corrupts absolutely. So we can't give absolute power to the government. We need to limit it, which is where fundamental right comes into picture. Now, why is it called fundamental? Because it is extremely important, right? In the absence of the fundamental right, the citizen is directly under the absolute control of the government, right? And this is something which is not desired because of our history, because we have come from a place where we were under the absolute control of the British Crown, us as well as the Americans. And this is the basis in which the rights have come into existence, right? And having said this, I would like to move on to our discussion on fundamental rights itself. And my discussion starts with two stories, right? In the year 1982, India was hosting the Asian Games. Okay. And during this time, it was a time of great pride for us. Okay. Because, I mean, today when we look at India, we have a very good standing at the international level, right? But in 1982, we were not doing that well at an international level, right? Which is why us hosting the Asian Games was a big deal, right? And the government was ecstatic. And the government was literally undergoing a complete infrastructural change in our country in order to show that our country is amazing in front of the people who are going to come and visit the games, right? Now, in pursuance of this, the government of India engaged contractors, and these contractors employed a large number of poor construction workers from all over India to build flyovers and stadiums and basically to enhance the infrastructure in general, right? Now, it was found out that these workers were kept under extremely horrible conditions. Their working conditions were not good. They were being paid extremely less, right? And you understand it, right? See, an infrastructure development, if it happens over a period of time, you can expect upholding of labor rights, right? But if it's happening in a crammed up manner, the government is not suddenly having a lot of money, right? So what do? They try to reduce their expenses. And the work of various social organizations was reflective of the fact that this was being done at the cost of the workers' well-being, right? Because they were paid less, their living conditions were very bad. And this was the basis on which a petition was filed before the Supreme Court. And the Supreme Court upheld the rights of the laborers. And they said that what the government of India was doing was against the laborers' rights, in the sense that their right against exploitation was being breached. Right? First story. Second story is, and this is extremely interesting, okay? There was this man who was 23 years of age and who belonged to this particular tribe of Assam. The name of the tribe is Tiwa tribe. Okay. And maybe some of you know about this, but I'm not sure. But he was arrested in the year 1951, okay, on the grounds of causing grievous hurt. Okay. Now, causing grievous hurt, the maximum punishment, if I'm not wrong, is maximum punishment. Okay, it could be less than that, but the maximum punishment is 7 years in imprisonment, right? Now, what happened was when his trial was going on, it was found out that he was mentally unstable to sustain the trial. So he was sent to a mental hospital for treatment, right? In the year 1967 and in the year 1996, there were two letters which were written to the prison authorities mentioning that this particular man was in a proper position to undergo the trial, right? And his matter was never listed, right? And this man stayed in jail for 54 years. And in 2005, because of the efforts of the NHRC, that is the National Human Rights Commission, it was found out that there is one person who is an under trial prisoner. Now, this is called as an under trial prisoner, right? Because he's not completed his trial. He's not convicted, mind you. He could still very well be innocent, right? Because his trial was not completed. It was found out by NHRC that this man is rotting in the mental hospital. He's not even transferred to a jail. He was in the mental hospital for 54 years, when in fact in 1967, the first letter of certificate to prove that he is stable to attend the trial was given by the mental hospital authorities, right? In this case, we realize that there was a violation of right to life and personal liberty of this person. First of all, it's not proved that he has committed the crime. Second of all, even if it was proven, the maximum jail which he would have gotten was 7 years, right? And he was in jail, he was in mental hospital for 54 years, right? So when he went to jail, he was 23 years old. When he came out of jail, he was 77 years old. The entire life was wasted, right? Now, here we realize that the first example that I talked about was about workers, right? And the second example that I talked about was of a man who belonged to a tribe in Assam. One common thread that we find in between these two examples is the fact that the people involved are belonging to the lower economic and social classes, right? So the question that comes to our mind is, if in 2021, a news reporter who's arrested gets a Supreme Court case listed within a matter of a couple of days and is granted bail, in the same country, a person who belongs to a lower economic and social class, his case is not getting listed for 54 years, right? Which makes us understand that the fundamental rights, in both cases, fundamental rights were breached. It was recognized that the fundamental rights is breached. But we realize that the fundamental rights is most useful for the people who belong to the lower classes. The economically well-off, the socially well-off, the politically well-off do not need the rights as much as the underprivileged, right? So this is something that we understand about the fundamental rights, which is guaranteed to us by our constitution. Now, while talking about the fundamental rights, I would like to delve into depth about certain rights, correct? And I'm not going to talk about all the rights. I'm already giving a disclaimer. It's not possible to talk in 45 minutes. I think I'm already going to extend my time, but let's see. But I'm not talking about all the rights. I'm talking about certain rights which are important for us to understand, right? And we also will talk about how these rights function in the legal system, right? Now, the first right that I'm going to talk about is the right to equality. Okay. Now, we think we know right to equality, but we don't. Trust me. Even today, there are so many times when I read articles, when I read judgments, and I realize that it is not as easy as it looks. It's not as plain and black and white as it looks, right? The gray area is the problematic situation. Now, Article 14 of the Constitution talks about right to equality. And Article 14 essentially talks about how equality before the law and equal protection of law, right? In other words, it means that a person will not be discriminated against on the basis of his caste, creed, religion, sex, gender, place of birth, place of residence, anything, right? That should not be the basis of discrimination, correct? If we look at the preamble of the Constitution, there is two kinds of equality which the preamble aims to achieve. One is equality of status, right? And the second one is equality of opportunity. Okay, so this is more or less the framework in which our constitution functions, right? With respect to right to equality. Now, let me give you an example of a case. Okay, and this is one of my favorite parts where I give you a hope and then I crush it. Okay, but it won't be completely crushed, don't worry. So this is the example that I'm going to talk about is a case which has actually happened. The case is the case of Nargish Mirza versus Air India. Okay, and it's a case which still baffles me. Okay, to talk about the background of the case, what had happened here was the Air India was essentially, in vogue in the during the 1900s, and they had service regulations, right, for talking about the regulations which regulate their employees, correct? Now, these service regulations had a stipulation which essentially had a disparity which was drawn between the male and the female in flight cabin crew. Okay, in other words, air hostesses for the female and air pursers for the male. They had different set of rules governing air hostesses and air pursers for the same period of time, and the difference of rules was with respect to pay and was with respect to their term of employment. Okay, so for example, one of the regulation essentially pointed out that a flight purser, who is the male counterpart, his age of retirement was 58 years. Okay, that's it, just one line, 58 years, age of retirement. For air hostesses, which is the female counterpart, their age of retirement was 35 years. Okay, now here itself there's a huge disparity. This is not it. It was either 35 years, or when they get married, if the marriage is within 4 years of them getting employed, or when they bear a child, whichever comes first. Okay, so to give an example, an air hostess who has joined the services at the age of 21 cannot get married without losing her job until 4 years. That is, until the age of 25, she cannot get married. Only after that, she can get married without losing her job. And after that, until and unless she remains without a child, she has the job. Right? Once she bears a child, her job is gone. Or let's say she has joined the services at the age of 21. She has gotten married after 4 years. She has not had a child. She still retires at the age of 35 when her male counterparts gets almost 20 more years. Right? And this was the basis, or this was the point of contention. It was raised before the Supreme Court that this is a discriminatory rule. Right? And the Supreme Court, to a certain extent, accepted, but it also did not accept certain parts, right? So what the Supreme Court did accept was the fact that a woman, after bearing a child, was considered to be worthy of, retirement. That was a rule that the Supreme Court quashed. Okay. But the age, the 35 years of age, was not quashed by the Supreme Court. And when I read this case, and I'm sure majority of us, when we read this case, the most striking thing for us is the age, right? Because there's a 20 years different, guys. It's not even 20, it's 23 to be precise, right? The air purser gets to be in employment for 23 years more than the air hostess on no appropriate grounds. Right? So how did the Supreme Court allow that to take place? Well, the Supreme Court went into an entire jargon of, what was the, line of occupation, what exactly was a job that the air purser was doing, what was a job that the air hostess was doing. And the Supreme Court finally concluded there was a reasonable classification between these two positions. Right? Now, we may agree with it, we may not. I do not personally agree with it. But we realize that, again, we are guaranteed the right to equality. We are guaranteed the freedom from discrimination on the basis of our gender. But rules like this still exist. Right? Now, right to equality is not absolute. And for that matter, none of our fundamental rights are absolute. Right? So just as we are not giving absolute power to the government, we are also not getting absolute rights and absolute freedoms. Every right has a reasonable restriction. Every freedom has a reasonable limitation, right? Now, right to equality is not absolute in the sense that the government is allowed to make certain special laws on the basis of reasonable classification for a certain set of disadvantaged class of people. Right? So if we uphold right to equality to the T, we cannot have reservation policy. We cannot have an affirmative action policy, but we do. And this is on the basis of the reasonable restriction which says that the right to equality of a person does not prevent the government from making laws which is for the protection of the weaker section of the society, right? So we have laws which are specifically giving reservation to the lower, to the people who belong to the lower social class. We have reservation with respect to gender. We have special laws made for children, right? And this is on the basis of this reasonable restriction which we have for equality. But the point remains that on the face of it, this distinction seems to be very legitimate, but it was misused, I would say personally, in the case of Nargish Mirza versus Air India, right? Now, having talked about right to equality, I would like to move on to right to freedom and right to liberty, right? Now, right to freedom is enshrined in Article 19 of our Constitution. Okay, very important freedom, very important right. And the entire name is right to freedom. Okay, that's the heading. And under it, there are subclasses. There's right to freedom of speech and expression. There's right to freedom of assembly. There is right to freedom of trade and profession and occupation. So many different kinds of freedoms which are guaranteed to us. But the common factor remains that this particular provision gives us the liberty or the freedom of thought, expression, and action. Okay. Now, once again, this is not absolute. Okay. So when I say freedom of speech and expression, it is not an absolute situation. So to give you a very simple example, which I'm sure all of us have known or heard, I have the liberty of moving my hand, but my liberty stops where your face begins, right? So I do not have an absolute liberty. I have a liberty to an extent that it does not prevent others from exercising their liberty, right? Which is the reason why the right to freedom of speech and expression is subject to other person's reputation, other person's morality, right? The society's public order, all of these other reasonable restrictions. I do not have the absolute right of freedom of speech and expression. Same goes for right to freedom of movement, right? I have a right to freedom of movement, but I have to follow certain rules. For example, if I am a witness in a trial, in a criminal trial, the police or the court might ask me to stay in the city till the trial ends, right? And I cannot say that this is a violation of my freedom of movement because reasonable restriction, correct? I have a right of freedom of conducting trade, following any profession, following any occupation, but I cannot get up tomorrow and sell drugs. Why? Because that is the reasonable restriction. I have a right to freedom of association, but I cannot form an association for selling drugs. That is a reasonable restriction. I have a right to freedom of assembly, right? But in 2020, the protesters at Shaheen Bagh were asked to vacate the premise because it was affecting others' right to movement. If you remember, the case was the traffic was getting affected, right? So those are the reasonable restrictions. Now, the question that arises here is what is reasonable? What is a restriction? We know. But what is reasonable is the problem that occurs, right? What is the extent to which we consider a restriction as reasonable? Is the restriction excessive? If it is excessive, it is not reasonable. If the restriction is arbitrary, it is not based on reason, it is not reasonable, right? If the restriction is unjustified, it is not reasonable, correct? So what is reasonable becomes the question. Now that is another discussion once again as to what is reasonable, but we're not going to talk about it out here. The next right that I talk about is the most important right in part 3 of the Constitution, which is the right to life and personal liberty. Okay, now what is the difference between right to liberty in Article 19 and what is the difference between right to life and liberty under Article 21? Under Article 21, it is personal liberty, which means that I personally have a liberty to move around. I personally have a liberty to do certain things, which is combined with the right to life. Correct? Now, under this, the rule is no one can be denied his or her right to life or liberty except based on the procedure established by law. Now, let's not look at personal liberty for a while. Let's look at life. Okay. It is saying that no one can be denied of their right to life. But my question is, when criminal trials take place, there are certain crimes for which the punishment is death, wherein the government is taking away the life of a person. When we say that no person can be denied of their personal liberty, there are crimes where the punishment is imprisonment, that is taking away your personal liberty. So how is that in existence? The reason is, once again, right to life and liberty is not absolute. It is subject to the procedure established by law, right? So if, in other words, if your life or if your personal liberty is taken away by the procedure established by law, it's absolutely fine, that can be done, right? For instance, correct, there are procedures on the basis of which a person can be arrested, right? There are procedures which run into pages, the CRPC, if you look at it, the Criminal Procedure Code, it is a procedural law which runs into pages, which tells you what is a trial and how does a trial take place. And only when the trial ends in conviction can you send that person to jail or can you imprison that person, right? So that becomes the procedure established by law. And when the life is taken away based on procedure established by law, or when the liberty is taken away based on procedure established by law, we will essentially conclude that it is allowed. It is not an infringement of my right to life and liberty. Correct? Now, here, one of the things which is very important is that it is not necessary that any kind of procedure is in place. For example, let's say tomorrow, see, what is a procedure established by law? What is a law? A law is nothing but a piece of paper which is validated by the parliament, which is the government, right? Now, let's say tomorrow the government comes up and writes on a piece of paper that the president is having the power to arrest any person. That is also a law, right? And let's say they give a nice procedure also. The president will appoint an officer, the officer will go to the person's house and will arrest the person, whatever. That is also a procedure. But that is not an appropriate procedure established by law, because the procedure established by law has to fulfill the requirements of principles of natural justice. That is, it should be based on fairness. It should be based on odi alterum partem, which means giving the opportunity to the other person to defend itself. And it should be based on the principles of equity, right? So you cannot have any procedure in place and take away the right and liberty, life and liberty of a person. It has to be a procedure which fulfills the principles of natural justice. It should also be a procedure which follows the principles of equality. So you cannot have, without a reasonable reason, different procedure of arrest for men and women. If there's a reason, then it's fine. But if there's no reason, you cannot have a differentiation, right? You cannot have arrest of a person belonging to a scheduled caste or a scheduled tribe in an easier manner, and the procedure becomes difficult for a person like Amitabh Bachchan. You can't have that, right? Because the procedure also has to fulfill the right to equality, correct? And here, one of the most important thing, when I talk about how it should fulfill the principles of natural justice, we essentially talk about the right to free and fair trial, right? So most of the times, the right to life and liberty of a person is taken away by the criminal procedures that we have, correct? And the criminal procedure, which talks about the trial of a person, has to be based on free and fair trial, right? Which means that, let's say I have committed a crime, okay? And my father is a judge in the case in which I have committed the crime. This is not fulfilling the principles of natural justice. This is not a fair trial. right? It is going to be obvious that the judge's opinion is going to be biased because he is related to me, the accused, right? Similarly, if the judge is the father of the victim, even that is problematic, right? Because the judgment is going to become is going to be biased, right? So freedom from bias becomes an essential basis of fair trial, on the basis of which life and liberty can be taken away. Another very important thing that becomes a part of free and fair trial is the fact that the person gets a reasonable chance to defend himself, right? And we have an elaborate system of courts, and we have an elaborate set of laws, which is not easily comprehensible to the common man, which brings in the role of a lawyer or the role of legal assistance, right? So, as a part of right to life and liberty, okay, it's not a separate right, but it is a part of right to life and liberty that every person has an access to free legal assistance. Free, right? So it's fine if you're not wealthy. It is fine if you belong to the lower economic class of the society. You still get a chance to defend yourself. You get a fair chance to defend yourself by being represented by a lawyer, right? To give you another example, Ajmal Kasab was the deadliest of the terrorists that India has seen, was also given a chance to have his own lawyer, to have a free and fair trial, and only after he was convicted was he punished, right? So that is the basis on which right to life and liberty exists, right? Now, this is the reason why we look down upon the dark times of emergency, right? Because during the emergency that we had, which was promulgated by the government, we did not have a right to life and liberty, which meant that anybody could be killed, anybody could be arrested. There was no procedure in place to ensure fairness, to ensure equity, to ensure unbiased opinion, nothing, right? This is the importance that right to life and liberty holds with respect to the Indian Constitution, right? Now, having talked about the aspect of right to life itself, we cannot forget that right to life is not a standalone right. It brings within its ambit many other rights. Okay. So, what the court has done is, now this is the court's game, right? The Constitution, plain and simply, there's only one line for Article 21. No person shall be denied right to life or liberty except on the basis of the procedure established by law. That's it. That's Article 21. But if you look at Article 21 in the legal books, it runs into pages and pages and pages. The reason is life and liberty is interpreted by the court to mean 100 other things, right? For instance, the court says that right to life is not mere animal existence. It includes the right to live with human dignity. Okay, which is why we have a separate set of laws for prisoners' rights, right? The worst class of the society, the people who are convicted of offenses, of crimes, we are not letting them live as a mere animal existence. We are giving them rights, correct? Second of all, the freedom from exploitation. Again, this stems from the human dignity angle itself, that it is not necessary that that I am only existing, I'm only living, but it is necessary that I'm living without exploitation, which is where the entire system of labor rights comes into picture. When it is not enough for you to only live, you should live in a manner which is free from exploitation, right? So there is minimum wages, there is minimum time for which you can work. All of these rules stem from this particular angle of right to life itself. Next is right to shelter. There was a case which had taken place wherein there were people who were pavement dwellers. And during the monsoon, these pavement dwellers were causing a lot of problem with respect to traffic and sanitation, because of which the government asked them to vacate the premises. And these pavement dwellers, I mean, they did not go to the court. On behalf of them, an organization went to the court and they were given the right of shelter. So the government was asked to not vacate the pavement simply, but if they are asking for vacation, they should provide an alternative housing for these set of people, right? Or for that matter, we also have situations of wrongful eviction of tenants, which is very much relevant to us, right? Not allowed because the constitution gives a right to freedom of, a right to shelter as a part of the right to life, correct? The next one is right to health. The free vaccines, which have come during the time of COVID, was a classic case of the government ensuring us right to health, right? Or the subsidized treatments that we get in government hospitals, right? In the absence of laws to give us subsidized treatments, we would have every hospital demanding a lakh of rupees per day for a hospital bed. We don't have that. That is the government ensuring us right to health, right? Next is right to clean environment. The recent judgment of the Supreme Court banning firecrackers is based on this right. We should not just be living, we have a right to live in a clean environment, right? And the last one and the most recent one and the biggest one is right to privacy, right? Which has been declared very recently, which means that the government cannot interfere in the private life of an individual. Now, right to privacy has been the basis for decriminalization of Section 377, right? The decriminalization of homosexual activities was on the basis of right to privacy. Right to privacy forms a very basic part of this particular judgment because it was held by the court that what a person does or what is the sexual orientation of a person within the four walls of his house is none of the government's concern. Makes sense? Also a part of right to life, right to privacy, correct? So this is the reason why I consider Article 21, that is right to life and liberty, the most important right, because it's very versatile. It is very broad. The interpretation has been done by the Supreme Court in an absolutely citizen friendly manner, right? Or a people friendly manner. And many rights have essentially been extremely helpful for the lower classes of the society, right? So that is one of the rights. The next most important right is the Constitution even grants rights to the accused. Now, accused is a person who has been complained against for committing a crime, right? Again, now this becomes very, very tricky, okay? It's obvious that we have to give rights to the accused, right? Because at this point of time, we are giving rights to prisoners. And prisoners are the ones who are held guilty of an offense. Accused is the stage before that, correct? And just imagine the situation of an accused person and imagine yourself in that situation, because all it takes to become an accused is one complaint by some random person, right? Now, an accused is a person who would either be guilty or innocent. If he is guilty, he still has rights because prisoners have rights, correct? But if he is innocent, what about that? While or during the process of him being an accused itself, his rights are getting affected, correct? And that is what the Constitution tries to improve to a certain extent. I mean, obviously, it is not possible to have complete rights given to the accused because the other possibility also exists that he is guilty, right? But there are multiple rights given to the accused. For instance, the most important right in criminal trial, a person shall be considered innocent until proven guilty, right? So simply on the basis of a complaint, you cannot treat the person as a guilty person. It has to be on the basis of a conviction that you treat him as a guilty person. And on the basis of this right of a person being presumed innocent until proven guilty, you have the rules of bail, right? Bail, which essentially means that you cannot keep a person in the prison for more number of days than what is necessary to conduct the investigation. Once your investigation is complete, let this person go free. You can arrest him back only after he's proven guilty, right? This provisions of bail come from this presumption of innocence of the accused, right? Second one is right to know the grounds of arrest. If you are being arrested by a police officer, you have every right to know the grounds on which you're being arrested. Once again, a limitation on the power of the police to arrest any person for no reason. So the police has to show you an FIR, that an FIR has been filed against you on this section, which is why we are arresting you. Or the police has to show an order of the magistrate saying that this person can be arrested. Without any reason, without any grounds, a person cannot be arrested, right? Next one is a right to be taken before a magistrate within 24 hours of arrest, right? The police cannot arrest you and keep you in prison for an extended period of time, right? Within 24 hours of your arrest, you need to be presented before the magistrate, wherein the police will request the magistrate to extend the custody of this person with them, right? And this is where the entire understanding of how police custody is more dangerous than judicial custody comes into picture, because the police is responsible for investigation, right? If the police gets the custody for a prolonged period of time, there is a possibility of using unfair means to investigate the entire crime, right? Wherein the police, and we have seen so many instances, right? Especially during COVID itself, we had the case of Felix, wherein a father and his son were arrested, and they were essentially, the courts were also closed during COVID, right? So that was considered to be one of the reasons why they were arrested, and the police had committed atrocities on them, and they ultimately lost their lives, right? To prevent that situation, we have the production before the magistrate, wherein every couple of days, this person will be asked to be produced before the magistrate, the first one being within 24 hours of arrest, so that the magistrate can ensure that his rights are not getting violated in police custody, right? Next is free and fair trial, which we have already talked about. Another one is free legal aid, which again we have already talked about. And the last one is the right against self-incrimination, which essentially means that a person will not be forced to give evidence against his own self, right? This is the basis on which a police officer or a court or anyone else cannot forcibly do a truth serum test on you, or cannot forcibly do a DNA test on you, right? If they have to get the truth from you, if they want to administer the truth serum, it has to be with your consent. You will not be forced to give any evidence against you, right? If they want to conduct a DNA evidence thing against you, they have to take your consent, right? So these are the rights which form the basis of many other laws which protect you from doing certain things, right? So after this, we essentially have the right to religion and the right to minorities, cultural and educational rights, correct? But I'm not going to go in depth with it because I'm being reminded that I finished my time. But let me quickly talk about it. So right to religion essentially means that everyone has the right to choose and to practice whichever religion he wants. It includes the right to follow a particular religion and also to profess a particular religion, right? So conversion is allowed under the Indian Constitution, okay? Next is, it also includes the fact that the government cannot take sides when it comes to religion. The government cannot have a state religion. The government cannot give more benefits to one religion over the other. That is something which is not allowed, right? Equality of all religion is what we stand for. And cultural and educational rights essentially belong to the minority community. Now, what the Constitution envisaged was that there are many minorities in India, right? And if we do not help or do something to protect the interest of the minority, we are essentially going to do a great disservice to them, which is why the Constitution allows educational institutions to be established by the minority community so that they can continue to maintain and preserve their culture, whatever minority culture they follow, right? So in this as well, the burden on the government is to not interfere in their matters, and the burden of the government is not discriminate against them, right? So if, for example, there's an educational institution which belongs to a cultural minority, the government is, let's say, giving free aid to all universities in that particular area. They cannot discriminate against the cultural minority university, right? That is essentially the burden of the government in this particular aspect. And the last and the most important right, which I'm going to discuss today, is the right to constitutional remedies, right? And the reason why this becomes the most important right is because whatever I talked for the last 45 minutes is absolutely useless without Article 32, that is right to constitutional remedies, right? What is this right? This right is essentially something that gives the citizens or the people the power to approach the Supreme Court and the High Court in order to complain or in order to resolve their grievances with respect to breach of fundamental rights, right? So if any of these rights that I've talked about of yours are breached, you have a direct access to the High Court and the Supreme Courts of your country and complain against the breach of right. Correct? And what will the High Court and the Supreme Court do? The High Court and the Supreme Court have two powers. One is give orders or issue orders, and the other one is give directions. That's what the High Court and the Supreme Court can do. They can either give an order saying that there is a fundamental breach, there is a breach of fundamental right, and they can give directions to remedy the breach. Right? So these are the two things that the High Court and the Supreme Court can do. Now, quickly summarizing the writs which are available to the citizens. Writs essentially means the type of petition that you file before the High Court or the Supreme Court. The type of petition, right? This becomes a little procedural. This is not something which falls within the substantive ambit of law. It becomes a little procedural, but whenever you approach the High Court or the Supreme Court, you have to approach on the basis of a petition, right? Now, this petition can be of either of these types, right? It can be a writ petition of habeas corpus. For instance, if you remember a couple of minutes back, I told you that a person cannot be arrested without any ground, right? If you are, let's say this right of yours is infringed, what do? You file a writ petition of habeas corpus before the High Court or the Supreme Court, wherein what will the High Court or the Supreme Court do? You basically complain that myself, or one of my known persons is being arrested without any grounds. The court will direct, okay? The court will direct, I told you two things, orders and directions. The court will direct the responsible officer to produce the person before the court and state the grounds on which he is arrested. And if the court finds that there are no reasonable grounds, the court can direct the person to be left, not to be arrested, right? The second one is a writ petition of mandamus, right? Let's say there is a government official who has a legal duty to do something and he does not do that, right? You can go to the court, and if his breach of legal duty is affecting your fundamental rights, you can go to the court and complain about the fact that someone's breach of legal duty is affecting my fundamental rights, and the court will direct that person to do his legal duty. For instance, let's say I'm living in a building, and outside my building there's a huge pile of garbage, right? The municipal corporation authority have a legal duty to clean that garbage, but they are not doing that, which is affecting my right to clean environment because there's a huge stench which is there outside my house. I can go to the court and complain against it, and the court will direct the municipal corporation to clean that garbage. This is the writ of mandamus, right? The third one is the writ petition of prohibition, which is a little procedural in the sense that, let's say a particular court is giving a judgment which is beyond its jurisdiction. Jurisdiction is the acceptable limits within which the court can give a judgment, right? For instance, a lower court can give a compensation, can grant a compensation of not more than, say, 1 crore. Or a lower court cannot grant death penalty, which is the case, right? So let's say there's a lower court which is granting a death penalty. you can go to the High Court or the Supreme Court, and these two courts have a right to direct the other people, the lower court, to not give a judgment beyond its jurisdiction, right? Next is the writ of quo warranto, which essentially includes a question which is put before a person, asking him what is the authority under which he is acting in a certain way, which is affecting the right of another person, right? And the last one is certiorari, wherein you can go to the High Court or the Supreme Court on the basis of an existing case which is going on in the lower court, and you can demand the High Court or the Supreme Court to take up the case themselves because it has certain special issue in question, right? And if this is done, or if this is accepted by the court will give a direction to the lower court to transfer the case to the High Court or the Supreme Court, right? So these are the writs which are available. Out of this, the most important for us is the first two, that is habeas corpus and mandamus, right? These two are the most important ones for us, wherein we need to know these in order to preserve our rights, right? They also infringe the most important rights for us, that is life and liberty, right? So with this, I conclude my lecture for today, which was about the rights, part 3 of the Constitution. And I hope I'm able to convey what the Constitution guarantees to us. And I also hope that I'm able to convey that whether we are completely guaranteed those things is another discussion altogether. Right? Thank you so much.
Thank you so much, ma'am. It was really nice of you and great of you to know, and you deep dive through a lot of rights, so which all of us had to know. And I'm very sorry that we had to remind you, because you unfortunately this is also a reasonable restriction, I could say, considering time.
No problem, Varun. You have to remind me. You should ask Gayatri what I used to do to them, poor things. I was affecting their rights as a student when I used to teach them, because I used to never stop.
Yeah. So I request all our viewers to please post your questions if you have any. So we have also gathered few questions. So with no delay, I just want to go to questions now. So ma'am, when we talk about freedom of speech or freedom of expression, right? So there is also a few set of reasonable restrictions which you already explained. But I see you quoted the Shaheen Bagh incident also. So there are many incidents which like this happens, where the reason of, the freedom of speech is exploited, and the citizens would take advantage and then go beyond. So what is your take on that? So should there be more restrictions?
Okay, so you're asking my personal opinion, just to clarify.
Yeah.
Okay.
Yeah.
So see, what I believe is, and see, there are two parts to this particular question, right? There are two opinions that can be given. One is that restrictions are extremely important, right, for the smooth functioning of the government. And the other part is personal liberty is very much important, because I'm the one who you're working for, right? That's mostly what the citizens say, when, especially the Shaheen Bagh incidents and all of that. Now, I believe where all of us are stuck is in between these two, right? And as a citizen of a free India, coming from a certain background, certain privileged background, if I may say so, I want as much liberty as possible. And I'm sure all of us do, right? But I think what all of us should try to do and aspire to do is look at the ground reality, right? And try to understand how absolute liberty is a boon for a person who can exercise this liberty, and it is a bane for a person who cannot exercise this liberty, right? So when we talk about the privileged class of the society, which includes myself personally, if you ask me, I want absolute freedom, right? I want minimum government interference. I want zero restrictions, and I rightly demand so because of the context from which I'm speaking. But we also need to understand the other side, and we also need to understand that it is not, everyone does not have the privilege to have liberty, right? Which is where the restrictions come into picture, right? However, when I think about protest, right? So if you, because you talked about Shaheen Bagh, I would like to bring this to light, that I think protesting is a very, very important part of a democracy, right? So apart from the fact that I have a right to freedom of speech and expression, which includes a protest, I also have a right to live in a democracy. I told you two principles that the Constitution upholds, right? And protest is engulfing both of these, right? Which is why I genuinely feel that protest is something which should be kept at a different pedestal than the rest of our rights, correct? However, I do not believe that violent protests is the way to go ahead, right? So maintaining law and order versus right to protest is the thin line of balance that we should try to achieve.
Okay. Moving on to next question. So we have, could you explain us the difference between what is an article and what is a section? And why don't we find sections in the Indian Constitution?
Great. This is a great question. And this is also a question without an answer. Okay. Because to give you in a very simple manner, I mean, this is again something which is open to interpretation. Okay. But something that I have noticed as to what is the difference between an article and a section is that whenever you're talking about a superior law, right, it usually includes an article. And when you're talking about the rest of the laws that we have in our country, we refer to them as sections, right? So Constitution is considered to be the superior law of our country, which is why we are referring to that as articles. And the other laws which form a part of under the Constitution, those are referred to in sections, right? If you look at international law, also a similar thing exists, right? The UN Charter has articles, right? But there are a few other rules which are called as rules. They are not called as articles, right? So a WTO agreement has articles, right? But the rules which are given under it are called as regulations, right? So that is the reason why, I mean, that would be the best explanation that I could give for what is the difference between an article and a section. In a sense, there is no difference. Both are things which we use to refer to a provision, right? But it's usually observed that the higher law gets called in articles.
Okay, moving on to next question, ma'am. So when we talk about right to equality, right? So you also told about a few of the reasonable restrictions there. So as we see, in 1950, there were few, considering the situation back then, there were few reasonable restrictions which was there. So do you think should we also work on right to equality and remove few of the reasonable restrictions from it?
Again, this is also a very interesting question. To which I genuinely don't have an answer. Okay, and this is coming from a place where I have you need to understand that I have moved from a place of extreme liberty to a place of to a place where I would question extreme liberty, right? So even with equality, the same logic applies that for people who come from cities, right, for people who belong to areas and geographical areas as well as social classes where your social status or your caste does not matter, we would believe that reservation is not of any use, right? But that is not the whole truth, right? So I would really suggest all of you to watch this interview which was given by Nawazuddin Siddiqui, if I'm not wrong. Okay. And I think there was some interview which was taken wherein he was asked about these issues of how caste affects him as an actor, right? And he makes a very, very sensible point, right? He says that in Bombay it is not a problem, but when I go back to my village, it does not matter that I'm someone who's nominated for the Oscars. It does not matter that I've become a very rich person. It does not matter that I am a household name now. All that matters is which caste I belong to, and the treatment that I would be given is based on that. Correct. Now, in such situations, we tend to think about how reservation is necessary, right? So if a person, now Nawazuddin Siddiqui is a one-off exception, right? But the majority of the people in his village are still living in the same setup, in the same background, living the same life in the same economic class, correct? Which is why reservation, I think, is still necessary. What we need to remove is, or what we need to include for that matter, is the creamy layer distinction, wherein probably some level of importance must be given to a person who belongs to a backward class as well as a lower economic status than a person who simply belongs to a backward class but is good enough economically, right? I think that might help a little. But I wouldn't say that that also helps absolutely, because see, then in that case, Nawazuddin Siddiqui does not get a reservation, but according to his own testimony, he does get discriminated against, right? So again, this is something which is which should not be looked from a privileged perspective, is what I feel. We should probably try to look at people who are actually getting the benefit of it and try to understand the impact of this education and try to bring about a reform through that, rather than completely, declaring it as something which is not needed.
Thank you, ma'am. So another question. So we all know that Indian Constitution has undergone 105 amendments as of 2021. Is it an advantage or disadvantage to the nation? Does this show the instability of our constitution?
Not necessarily. Now, I'm a person who is absolutely in favor of amendment. I do believe that I that's the reason why I am in favor of basic structure, or that is the reason why I am of the opinion that the procedure that we have for amendment, the procedure for amendment of the constitution is different from the procedure for any other law that we pass, right? It's a little more difficult to pass an amendment legislation, right? Because it requires a higher level of majority in the parliament, correct? That I agree with. But I do also agree that amendments are important, or the provision of amendment is very important in order to keep up with the changing times, right? In order to ensure that your document does not become a document of the past, which we are still stretching, right? And if you look at the jurisprudence surrounding amendment as well, even everyone says the same thing, that it should not be as easy to amend the constitution as it is any other law, but we need to have an amendment procedure. So whether 105 amendments are necessary or good for us, definitely not, because there are many amendments in between which reflect the selfishness of the government, rather than actually making the change to help the population or to make the constitution in vogue with the context. But I do believe that amendment as a provision is important.
Considering time, we'll have one last question. So there was emergency declared at various points, right, from 1947, if you see. So considering the current situation, don't you think the government had to or has to declare it as health emergency because of the COVID surge, obviously?
Okay, emergency is not an option. I'm someone who is completely against emergency, and this is a very fun fact. Okay, where we have adopted the provisions of emergency from? We have done it from the German Constitution. Okay, and I mean, that itself makes it most questionable. Okay, because we understand that Germany's past comes from Hitler. Okay, and Hitler in fact came into power using emergency provisions. Okay, so if you look at, I mean, it was not exactly the replica of the Indian emergency provisions that Germany has, but what he did or how he came into power was because the government at that point of time, the head of the government, I think, had died or he had left his office, and the government declared an emergency at that point of time. And that is how Hitler came up with all his laws, right? His Semite laws, correct? So I do not agree with the provisions of emergency even in this situation, the health situation. I think in that consideration, India did a good job by declaring it as a disaster, right? Under the Disaster Management Act, that's what India did. And of course, it got huge powers under that as well, because in order to contain a disaster, you need to give more powers to the executive, which is something that India got. But it also got to get away with an extreme emergency like situation, because in emergency, as soon as your rights go, the whole thing becomes questionable, right? So if it would have been declared as a health emergency, we would not have been able to file the petition for the migrant workers who had to walk back, right? Because the court would have said you don't have rights, right? We could not have been able to request the court to accept the cases of domestic violence because you would not have rights, correct? But because it was declared as a disaster, what the government could do was it could use its excessive powers only for the purpose of containing COVID. And there was a possibility at least to file these cases and for the court to listen to these cases. It's a different thing that the court did not help, right? The migrant cases, the migrant workers cases was not really, it did not conclude with a reasonable solution on the part of the court. But the fact remains that we at least could file a petition and expect the court to listen to the petition. If it was an emergency, there would not have been any petition.
Yeah, thank you so much, ma'am. I think that the answer that you told that we derived it from the Germans itself was a pen drop moment, I felt. So I think with this, it was really great to have you today, ma'am. So I just want you to give the final remarks before we wind up.
Final remarks. I have none. I think fundamental rights are very important. I think the Constitution is very important. I mean, the more you read about the Constitution, the more the beauty of it reflects, right? And it is a beautiful piece of legislation, right? It is one of those things which I don't think anyone can truly call themselves as a master of the Constitution at any point of time, right? And I would like to say this as the last comment, that do not think that the fundamental rights is all and it. Okay, because it's not, right? The Constitution's beauty lies in every part of it than just in part 3, right? I think this is going to be my mantra to get away this false inhibition that Constitution is all about part 3. Okay, so thank you so much, guys. It was great talking to you all. I really enjoyed giving this lecture.
Thank you so much, ma'am. So it was really great to have you here today. And I know it was very short notice for you, but still you made some time for us. So once again, we from Rotaract Club of Yelahanka are very happy and extend gratitude to you. Thank you so much. And thank you so much for all our viewers who has joined us today. Once again, happy Republic Day and bye-bye. See you.